All right, let's dive into a really fascinating story. We're talking about what happens when a condo owner, a fitness coach, and a very powerful homeowners association all clash. It's a story about rules, rentals, and a conflict that ended up costing thousands of dollars. And it raises some huge questions about who really gets to control a community.
$6,900. This is the number right at the heart of our story. It's exactly how much rental income a condo owner lost in just 1 month. So how did this happen? Well, it all started when the HOA suddenly shut off his renters' key cards. We're going to break down exactly how this thing escalated and why it ended up in court.
You know, at its core, this whole dispute was really about interpretation. One guy saw a totally normal lease agreement, but the homeowners association, they saw a business operation that they felt threatened the entire character of their community. So let's unpack how this simple disagreement just completely spiraled out of control.
Okay, so to really get what's going on here, we first have to meet the cast of characters and look at the chain of events. Because this isn't just about a rule book, it's about how different people reading the same rules can end up in a major clash.
First up, let's meet the key players. On one side, you have George Lord, an owner with several units in the complex. Then you've got his renter, Barrie Shepley, a fitness coach from Canada who needed a place for his personal best training camps. And right in the middle of it all, you have the Boulders HOA, the group in charge of making sure everyone follows the rules.
And man, things escalated incredibly fast. So the leases get signed back in December, but just look at what happens in March. The fitness camp guests show up on the 7th, and just 2 days later, 2 days, the HOA deactivates their key cards. No pool, no gym, nothing. By the beginning of April, the entire deal is dead. A 4-month agreement completely fell apart in just a few weeks. Wild.
So, let's flip the script for a second. What was the HOA's perspective? For them, this wasn't some crazy overreaction. They believed they were watching a clear, textbook violation of the community's most important rules.
And they made it official, fast. This quote is from an email the community manager sent just 2 days after the campers even got there. It's accusing the owner of violating the CC&Rs. That's basically the community's rule book. The HOA's claim was simple. This isn't a normal lease, it's a subleasing scheme.
So the HOA's case was built on a few key complaints. First, they said this was a commercial operation, not someone just living there. They argued the campers were paying for short-term stays, which broke the 30-day minimum lease rule. And on top of all that, they claimed the owner never even told them who was actually staying in the units.
And this was their power move. Instead of just sending warning letters or fines, the HOA took direct action. By shutting off those key cards, they cut off access to the pools, the fitness centers, all the stuff that makes a luxury condo feel luxurious. This one single action is what directly led to the renter bailing and the owner losing that $6,900.
Okay, so that's the HOA side. Now let's pivot and look at this from the owner's point of view. As far as George Lord was concerned, he had done everything by the book. He had a totally valid lease with one guy, and he believed the HOA was way out of line. This slide just nails the core of the problem, doesn't it? The owner, Mr. Lord, was insisting, hey, Barrie Shepley is my only renter, and these other people are just his guests. But the HOA saw it completely differently. They said, no way. These campers are paying for a package that includes a place to stay. They're basically short-term renters.
So the owner's legal argument was pretty simple. He said, look, I have a lease with one person for more than 30 days. End of story. He argued that what his renter did with his guests wasn't the HOA's business, and that they acted illegally by punishing him without any real process. So of course, this whole mess ends up in front of an administrative law judge. Both sides make their case, and the judge had to sift through all the details to figure out who was right. And honestly, the decision is a masterclass in looking beyond the exact words on a page.
This was it. This was the question the entire case came down to. So what do you think? Was the owner just using a clever loophole in the rules, or was the HOA totally overstepping its power? The judge had to make the call.
And you know where the judge found the answer? Not in the lease, but in the fitness camp's own brochure. The evidence showed that the price you paid for the camp changed depending on how many people you shared a condo with. If 2 campers shared, it was over $1,200 each, but if 4 people shared, the price dropped to $950. That little detail turned out to be the smoking gun.
And this led the judge to a concept called de facto subletting. It's a fancy term, but the idea is simple. The judge said, look, if the cost changes based on how many people are staying there,
then those people are, for all intents and purposes, paying for their lodging. They weren't just guests. It might not have been called rent, but it walked and talked just like it. It was a business deal.
And this really gets to the heart of the whole ruling. The judge looked past the literal words, the letter of the law, and focused on its spirit. Why does a 30-day minimum lease rule even exist? The judge said it's to maintain a stable community, to know who your neighbors are, and to avoid what they called an itinerant population, basically a constant flow of strangers. The fitness camp, with new people coming and going, was found to violate that very principle.
And so, the final decision came down against the owner. The judge found that the HOA was actually justified in what it did, because the rental setup, while clever, ultimately broke the purpose of the community's rules. The owner's case was dismissed.
So, why should you care about this one little dispute down in Arizona? Because it has some really powerful lessons for anyone who lives in, owns property in, or even rents in a community with an HOA.
So here are the big takeaways. First, you've got to read the documents, and you have to understand not just what they say, but what they mean. This case proves that the spirit of the rule can be just as important as the literal wording. Trying to find a clever loophole can really backfire. And as we saw, these fights can get expensive, fast. A little clear communication at the start might have avoided this entire mess.
And all of this leaves us with a much bigger question. In this case, the HOA was seen as protecting the community from basically turning into a hotel. But it really makes you think, where do you draw the line? This is a perfect example of that constant tension between an owner's right to do what they want with their property and a community's power to set its own standards. What do you think?